my caseworker wants to contact me. And only that she want to contact me, they're vying to remove my daughter from where she's been in the care of my family.
All right,
And
hold on a second. Does your father, who has the child, does he have an attorney?
my dad, and no, I'm not sure if they do or not. But I believe that minors counsel, does not support this idea at all.
Let's go to line 4. Summer from California. Summer, did you have a question to ask or a story to tell?
Actually, bit of each, if I may.
You may.
Okay. I have 2 children. I have a son who is nearing double digits and a daughter who is nearing single digits. I am married, and that's where the basic, simple things end. I've had a couple of cases with my son in Los Angeles County, CPS. At this time, my soon-to-be ex-husband has physical custody, but we share legal custody. I believe that was intentional because I firmly believe that DCFS intends to take my son and eventually from my husband and place him into foster care. The reason I believe this is because the entirety of our cases have all been the same. There's never actually been anything that I've done. I've been the offending parent twice. Once I was asked to leave the house, and then once our son was taken from our house and placed in care of my mother and my father at one point. And now my daughter, who was taken directly from the hospital, she was born 2 months early because I had a heart attack and found out that I have a heart issue, which would not allow me to carry her any longer. I carried her as long as I could. She was born a couple months early, but she was born robust and healthy and thriving. And I did not tell DCFS that I was pregnant. Our case was due to end. The judge ended up extending our case by about 3 months because, as she put it, there was nothing to stop us from getting back together. It's as if a family reuniting is the worst thing that could happen. And so once they found out that I had my daughter, they shut up the hospital and were not very happy with me at all. The next thing you know, I know where there's an allegation that there are drugs in my system, stimulants. And again, I want to remind you, I have a very serious heart condition. According to the doctors, I could walk upstairs too fast and click off. I'm 42 years old. I did not have this heart condition prior to dealing with them. It's only developed in the past 6 years, and it's believed to have developed because of stress. The only stress that I've had to deal with is them. As it stands now, I believe it's 21E hearing, 6 months hearing, which I am contesting because the caseworker, I haven't even spoken to her in 4 months. She doesn't return calls. She doesn't talk to me. I don't matter. My child is placed in the care of my father. Initially, she was to be placed elsewhere. And while that particular family member was at the hospital awaiting my daughter's discharge, a supervisor called her and said that my child was placed elsewhere and hung up the phone. My daughter was placed out of county with people who were not family for about a week and a half or so. And then inexplicably, the day that our hearing, not the detention hearing, I'm sorry, but the jurisdiction hearing happened, she ends up in my father's care. I didn't necessarily want her there, but I had to deal with it. It was better than her being with strangers. Over the course of the first 2 to 3 months that she was there, all kinds of motions were filed, and my medical rights ended up being removed from me and given to my father's wife, who is my daughter's primary caretaker. So I visitation, I didn't get a monitor. I was ordered monitor visitation. My daughter was taken in the end of March. My caseworker didn't see it fit to get me monitors until the end of July. And she was very slow going. They were admonished once by the judge, but didn't seem to matter. Here we are. I get the report. The report is chock full of inaccuracies. I'll just say that. That's what I can say it. And I mean chock full. It just so happens that my caseworker on this case with my daughter is the same caseworker that I had with my son. And somehow, inexplicably, she contends that I still have an open case with my son when she knows good and darn well that case is closed and jurisdiction terminated. It's stuff that's blatant like that. There are even sections of the report where the placeholders are still in place. Like, it's very, very sloppy. And so naturally, I'm contesting the report. Lo and behold, out of nowhere, my caseworker apparently wants to move my daughter from where she's been. Now they want to move her, contending that there's an issue that happened with my father 30 years ago. This matter happened 30 years ago. It was resolved 30 years ago. He was exonerated 30 years ago. They were well aware of it when my son was placed in his care 2 years ago, let alone my baby. And now, all of a sudden, now that I'm contesting the report, my caseworker wants to contact me. And not only does she want to contact me, they're vying to remove my daughter from where she's been in the care of my family.
All right,
And
hold on a second. Does your father, who has the child, does he have an attorney?
my dad, and no, I'm not sure if they do or not. But I believe that minors counsel, does not support this idea at all. And I believe that they're going to go to court this upcoming week. I'm hearing all about this secondhand. My own attorneys have not contacted me about it, but I believe that they could be gearing up for a hearing. We're hearing it the 5th of November.
Okay, so Summer, because we're running out of time, let me tell you what you need to do, okay?
Okay.
All right, you need to sit down or talk to your attorney, get your witnesses subpoenaed to court, get your exhibits subpoenaed to court. Because of those inaccuracies in the report, you're going to have to counter them with witnesses or with exhibits. Unless you subpoena these people, they're not going to show up and you're going to lose. You want to make sure that you have a witness list and an exhibit list. In my opinion, from what you've told me, your attorney will know better. This would not be a case where we just argue and not present any witnesses,
Absolutely not.
Which happens a lot of times. I see this happening. And not calling witnesses is not a good thing if you're trying to win a trial, because the only evidence in court is the social worker's report, which is chock full of inaccuracies, as you said, and the lawyer's arguments aren't evidence. So understand that the arguments made by your lawyer are not evidence. Okay. So if you only have the exhibit from the social worker, which is the report, into evidence, by definition, 9 times out of 10, you're supposed to lose.
Right.
Right.
I mean, and I agree with you.
Do me a favor, Summer. Do me a favor. Talk to your attorney, make an appointment, come up with a plan, implement the plan and the strategy, subpoena your witnesses, subpoena your documents, and then go forward with your 2-1E hearing. And for our audience, that's Welfare and Institutions Code, section 366.21E. You can Google it and you can see what it says. Hey, Summer, I want to thank you for calling and thank you for listening. We have to take a break right now. We'll be back after these messages.